Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. And the content that we're going to talk about this morning was supposed to be last night's video, but I'll be honest with you guys, I'm in the middle of moving and it's kicking my butt. So I apologize, better late than never, but let's talk about the Supreme Court's new pattern in emergency relief for Second Amendment cases where infringements are clearly obvious. We're going to break all this down because a pattern is establishing now between New York and the most recent breaking news of Illinois. Everything is going to be linked in the description box below, and I cannot wait to hear from you guys on this one because this is an important one to send out as we break down what it looks like they're doing. And if you are new or you are a returning viewer, please consider hitting that like button, subscribing to the channel, and making sure you turn that notification bell on. We need as many of you as possible to get into the fold with us so that we can pass the blessing of the Second Amendment along to the next generation through sharing information just like this, and thank you in advance for your consideration. But my brothers and sisters, what we're going to do now is we're going to break this down from the obvious breaking news that we hit yesterday about Illinois assault weapon ban going before the SCOTUS in a request for an emergency injunctive relief being denied. Now, initially, that's a wet blanket because they could have just cut this off right now from the high court stepping down and intervening and knocking it out. We had the exact same outcome in New York the beginning of this year in January. So what's going on with that? Again, this is complete conjecture. I'm merely offering what it looks like from the outside from observation. I obviously was not in the room with SCOTUS when they made these determinations, but let's look at the layout of the field, and you guys tell me if you see where I'm coming from, if you agree, because this is a very interesting concurrence of events. So as you guys know, and we covered yesterday in a breaking video, Supreme Court rejects challenge to Illinois assault weapons ban. Now, a very high level, this was appealed directly to Justice Amy Coney Barrett. She said, let me take a look at what's going on with the assault weapons bans as the case was going through the system. That's where we were at. As the system was churning through all the case details and the appeals and all those different pieces, there was a request to get the SCOTUS involved and let's just take care of it. No reason to go down this whole litigation path. That's the best way to say it. So they came back and they said, nah, let the system work its magic. Again, we're going to get to that in a second. But let me show you what they said and how they said it, and then we're going to tie it together to what happened in New York in January. Washington. The Supreme Court on Wednesday declined for now to block a new law in Illinois that bans assault-style weapons such as the AR-15 semi-automatic rifle. This part right here is important. The decision in a brief, unsigned order means the Illinois law enacted in the wake of the whole Highland Park tragedy will remain in effect while legal challenges continue. In a separate case, a federal judge blocked the law, but the 7th U.S. Circuit Court of Appeals has put that decision on hold. That's where we sit with it. But again, the emphasis was let the court system work this out. Because last year in June, they came out with the Bruin decision, right? So why would you want the Bruin decision to come out in June and then all of a sudden completely negate all the other courts when they are supposed to be implementing your decision? In fact, this is where it comes in. It gets very interesting. Going back to January, this is the Supreme Court decision in the New York carry sensitive cases case. Supreme Court lets New York enforce gun law during lawsuit. So this is again a mirror example of the SCOTUS not swooping down and intervening when it's clearly unconstitutional and it is clearly a violation of the Bruin decision. So what's going on? Let me show you some of the words that Alito said, which can give us a little bit of insight to maybe what they're thinking, because it does make sense if and only if this is what they're thinking. New York, for now, can continue to enforce a sweeping new law that bans guns from sensitive places, including all of these places, said the Supreme Court on Wednesday, allowing the law to be enforced while a lawsuit over it plays out. There's that playing out again. Playing out in Illinois, playing out in New York. It looks like they're doing something very intentional, but let's keep going. The justices turned away an emergency request by New York gun owners challenging the law, exactly like Illinois. The gun owners wanted the high court to lift a federal appeals court order that had permitted the law to be in effect, exactly like Illinois. You're seeing a pattern that's developing, and this last piece, where Alito writes with Thomas, gives you a little bit of insight, and then I'll kind of show you what I'm thinking here. In a 2-paragraph statement that accompanied the court's order, Justice Samuel Alito wrote that the New York law at issue in the case, quote, presents novel and serious questions. But Alito, writing for himself and fellow conservative Justice Clarence Thomas, said they understood the court's decision not to intervene now to reflect respect for the appeals court procedures in managing its own docket, rather than expressing any view on the merits of the case. They are letting the system work. Now you see it in New York. You just saw the exact same thing in Illinois. The premises are very similar, the actions are very similar, and the result is very similar. If you look at all of these, or both of these situations, it looks like the court is saying, we're not going to swoop down and get involved in the lower court deals. We're going to expect them to enforce our rules through Bruin. Now, whether that happens on the district level or the circuit level, that's a totally different thing. It looks like SCOTUS is saying, out of respect for the court system, we're going to let it work its way up. And that's where they're going to go. Now, this is where it gets interesting from a backed out perspective on people, on organizational leadership, on those things of which I have a background in. You always let the system work as it's designed, and even if it's flawed, you let it get to the end where you can correct the indecision and then use that decision to back in and say, why did you do this? And then back in further, why did you do this? And then correct it as it goes. If this is part of an entire scheme to restructure and rewire the decision-making process around the Second Amendment, this is how you would do it. You would let the entire decision work its way through the circuits until they ran afoul of the decision you just made in June, and then corrected it at the Supreme Court level, and then work its way down on saying, hey, remember how you did this? That was wrong, adjust it in the future. That's my thoughts. Again, that is pure conjecture. That's the way you would do it in an organizational leadership. But let me know what you guys think in the comments below. I will see you on the next one. I'm Braden. Thanks for stopping by.